If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening. So, Mr. Reyna, are you Mr. Reyna?
Yes, miss.
What you are about to watch is not your typical hearing. There is no plea being entered, no sentencing happening today. What this is a judge spending close to 10 minutes giving one of the most thorough real-time legal educations you will ever hear in a courtroom. A defendant did not show up dressed for his own jury trial despite being told to by jail staff. He wants a new attorney. He does not understand why his case might carry mandatory prison time. And by the end of this conversation, this judge will have explained the entire mechanics of court-appointed attorneys, plea offers, criminal history, and even the color-coded meaning behind every uniform worn inside that jail. This one is dense, but it is also one of the clearest windows into how the system actually works that you will find anywhere.
All right, so it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Well, believe it or not, Ms. Boyd, I wasn't aware of this trial in the first place. And
no, because here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial.
Stop right here, because what just happened is more serious than it sounds on the surface. This defendant showed up to court not dressed for his own jury trial, despite being told by jail staff that he needed to be. And the judge made something unmistakably clear. The next time this happens, he goes to trial exactly as he is, in that red jumpsuit. And she is explicit that if that happens, it will not be the court's failure. It will be his choice. In Texas, what a defendant wears in front of a jury can have a real impact on how that jury perceives him before a single piece of evidence is presented. A jumpsuit signals incarceration. It signals guilt before the trial even begins in the minds of some jurors. This is not a minor wardrobe issue. This is the judge protecting this man from himself one final time.
And when you're tired, you were told before and you didn't do it. And guess what? If you ever come back to this court.
And right here, the judge begins one of the most important explanations any defendant facing a felony charge will ever receive, and it directly addresses a request that comes up constantly in courtrooms. He wants a different attorney. The judge explains plainly that court-appointed attorneys are not randomly assigned, without standards. They come off a wheel of attorneys who are specifically qualified for the level of charge involved. For a third-degree felony that could be enhanced to a second degree, that attorney must have prior experience trying felony cases, not just misdemeanors. The judge is making clear that this is not a courtroom where defendants get to shop around for an attorney they personally prefer. If he wants someone different, he has exactly one option: hire one himself. What do you think most people assume about how court-appointed attorneys are chosen?
Where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit?
This is one of the most misunderstood parts of the entire plea bargaining process, and the judge breaks it down with complete precision. She explains that the state can make literally any offer it wants. It could offer the statutory maximum. It could offer something the defendant considers absurd. And here is the part most people do not realize. The defense attorney has no actual control over what number the state puts on the table. What the attorney does have is an ethical obligation to relay that offer to the client regardless of how unfavorable it is. The defendant can accept it, reject it, or counter it. But the attorney being the messenger of a bad offer does not mean the attorney failed at his job. That distinction matters enormously, especially when a defendant's frustration with an offer gets misdirected at the person sitting next to him in court.
Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That is correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What support for what?
It's ordinary to hire an attorney.
Oh, well, then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening when you as a defense attorney are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely, really no control over what the state is offering.
So
even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
It was at this moment that he knew he fucked up.
Why does my case carry at least prison time and not probation?
Here's the thing. You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you, though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that, and I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you said you pay me back on this day. You're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, That is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. Is your attorney. Do you understand? The other thing I want you, that's either yes or no.
Yes, miss.
The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females. Orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer and it may or may not appear for you again. Do you understand?
Yes, miss.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes, miss.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez,